Can you hear me?
Yes.
Okay. Okay. So we have about I want to say there's about 6 cases that are outlined in the presentation, and I tried to include what I could with library related stuff, and there's obviously going to be some other stuff in there, but each case is going to be presented as what was presented to the court, and then we'll go through the 4 factors, and based on each factor, how we felt, whether or not that was fair use or not. And then at the end, very similar to what I did the other day, we'll see how the Supreme Court actually ruled on that.
Uh, it's Christy again. Yes, and one of the emphasis about what we're doing is that we can get some experience in trying to apply the fair use principles that we had learned about, try to take a guess or try to give objective um, responses to the details that we have on hand and then go with it. And this is a very low stakes setting. Nobody is being graded on this or anything. You're going to have a lot of possibilities in each of these examples, and let's just hear what each other has to say in the courts. You're more than welcome once again to have your comments or your thoughts in chat. It's been very nicely active the last couple workshops, so let's keep that going. So, okay, Tom.
Okay, so Christy, this was something that you had asked me to include in this. I don't know if you want to talk about this. This is the checklist.
Yes. So we're going to talk about the cases today, but one of the things that I wanted to let everybody know about was the fair use analysis and checklist form that is available for everyone. This is a form that is based on the Cornell University fair use analysis checklist, and also some information passed along by Kevin Smith, library attorney, and others that he works with. The first part is where you put down some details about a copyrighted work that you or somebody else may wish to work on or reuse. You list some details such as its format, who the copyright holder or owner may be, how long the work will be used, and the why, and why you want to use the work and how much you want to use of it. Then on the other side, we've got the fair use analysis checklist. So here the 4 factors are presented, like the purpose of the use and work's character, the amount, the nature, and the effect on the potential market. So in each little box, you have things that weigh towards fair use, and then for that particular factor, and then things that weigh against fair use, also for that particular factor. So this has really been made available to help you and others, whether they're faculty, instructors, or even students, help determine and decide based on their own risk tolerance, whether or not their use would be a fair use. So this is available for everyone. You're welcome to distribute it, to use it, to copy it, just like they had done for their information. And I'll put the URL to that because it is available in our LibGuides. So the URL for this form is in the chat now. So it's available for everybody's download and use. So thank you, Tom. I just wanted to give a pitch for a tool that's available for us to help make these fair use determinations, but also to keep record of it.
Okay, so in no particular order, just to go over again, once again, the exclusive rights that a copyright owner has, and they can reproduce copyrighted works, they can prepare derivative works. Again, this is all stuff that you have to determine whether or not any of these rights have been violated by any of the cases that you're going to see. So they can also distribute copies for sale, etc. And you can, I don't want to read the whole slide here, but I mean, these are the exclusive rights that we need to determine whether or not they've been violated or not. So I'm going to move on to the next screen because this is another iteration of the other day's presentation. And again, we're looking at the 2 categories. We're looking at commentary and criticism, which is generally going to be fair use, and parody, which is generally going to be fair use, but not always in either case. So the first example I have is an early library example from 1973. And yeah, I am going to read this. Uh, the plaintiff, Williams and Wilkins Company, was a major publisher of medical journals and books. Defendants, National Institutes of Health and National Library of Medicine would, upon request, photocopy articles, does that seem familiar to anybody, and medical journals published by plaintiff and distribute them to researchers. Defendants did not monitor the reason for the copy requests, and the requesting researcher could retain the copy permanently. Plaintiffs sued for the copyright infringement and defendants raised the fair use defense. So, based on this and looking at the early library example, based on factor one and what we know of it, or hope to know of it from the other day, is this fair use? And if you want, I can scroll back up to the actual case. Would that be a good idea?
Ah, sure. Let's just review that one more time there.
Sure.
So a book publisher of medical books sued the National Institutes of Health, the National Library of Medicine, because they would photocopy their articles and give them to the researchers. So the defendant said that they did not really keep track of the reasons for these requests, whether interlibrary loan or just a personal request, or ask what the researchers were going to do with them. And they just assumed the researcher would keep the copy. So then the publisher turned around and sued the National Institutes of Health and the National Library of Medicine for doing this. But the defendants in this case said what they did was fair use. And Tiffany joined us. We have a good medical example for her as our medical
Should we
librarian.
leave it up for another second just so she can get
Uh,
the gist of this?
yeah. So, um, so when you think about what we know so far, and you got the first factor, which is the purpose or character of use. Let's see, would this constitute a nonprofit educational use or commercial use? Is it a transformative use? What are some other things we discussed about what could help us determine this first one, this first factor? And it was a research institution, a government sponsored one at that, and it's nonprofit. So there's an educational use there. You could make an argument for that. Okay, and then Ken did say the copy itself was not being used for a
I have a
profit.
meeting at 1:30.
And then Lori said that their use is not transformative, but then you don't know if this would be for commercial purposes by the end user who now has continuous access to it. Okay. Brian says that since the NIH and the NLM did not monitor who was receiving the articles, it cannot always prove the purpose was educational always. So that's another consideration.
Interesting.
True, we're not really sure what exactly they're doing with that. Yeah, and if you could just go back to the slide. There we go, thanks.
I mean, I can't imagine personally how anybody could take this as possibly being anything but educational.
True, yeah. Okay, so do you want to take a stab at the first one then, Tom?
At the I'm gonna say this is fair use. That's fair use in my book. But you know, I'm a librarian, so maybe I'm tainted in that sense.
All right, so why don't we go on to the first part? I mean, the pain, the factor one purpose.
Okay, well that was factor one. You want to go to factor two?
Sure.
Okay, did anybody agree with that was fair use? Based on the factor one, not on the whole, but on factor one, was that fair use?
Okay, we've got 3, 4, 5, 4 yays probably. One says hard to prove, but can be assumed. So it looks like we've got
Okay.
majority say yes, but there are a couple people that say perhaps or maybe.
I say perhaps on every one of these things, but I'm going to go with my guns and say fair use on that one. So factor two, the nature of the copyrighted work. Is this fair use? Factor fiction, creative works.
Okay, well, use of fiction is like less likely, okay? And assuming that these articles are based on fact, that is, they were research articles in STEM and medical journals, so these would
I'm
be,
assuming they're factual.
yeah,
I hope.
right. So because of that, they would get more, I mean, fair use tends to be in the favor there. Yep, so Leah says factual, so fair use in this factor. Lori says yes. Um,
Okay.
mhm.
Okay, let's move on to factor three because we got several cases here.
Okay,
Factor three, the amount used. Now we don't know exactly how much they were using, so that's a big issue here too.
yeah, I
We'll
mean,
we'll, we'll see that in the Supreme Court's decision.
okay. But I see that the less you take, the more likely your copying will be deemed fair use, okay. Um, And then also the big part that you emphasized, Tom, was the heart of it. So
Hmm.
it's not just the quantity of what's used, but the quality or what is copied, like something that's almost irreplaceable or the major reason people want to buy it in the first place.
Right, and in our limited, that we're going to be limited in what we know about this, based on what we read.
Yeah.
Excuse me, but what was presented to us. But again, we're limited, so this is kind of a real guess here about the amount used.
Yeah. Yeah. Ken says it sounds like they are sending a complete article. Um, Leah thinks it might not be fair use. I'm not,
Hmm.
that's a possibility too, for sure.
Hmm.
Especially as we get more details.
Okay, so that's just three factors, but so let's go to the fourth factor because, and again, none of it could be 2 to 1, it could be 1 to 2, it could be 3 to nothing, but we're gonna have to weigh this in the end based on what we feel outweighs everything else.
Mhm.
So factor four, the effect on the market. Is this fair use?
So is it depriving the copyright owner of income? Mhm. So,
Kenny Cruz had a quote where he said that you have to build upon earlier research and earlier works. So to me, that right there, tells me that this is fair use because you have to build on something somebody else already put out there.
mhm.
So I'm leaning towards fair use, and I mean, I don't
Yeah,
know. Does anybody disagree?
hmm. Yeah, people are saying this probably is. Ken says that, it may be fair use only if the individual receiving the article would have subscribed to the journal. Um, Deepa said they should have paid for the articles to use in their research. So I'm assuming this is the Library of Medicine, the National Library of Medicine. They'd already paid for it, and they're
Mhm.
just distributed amongst their scholars. Mhm.
Okay,
So
so
it's
that was for the four factors, but in your opinion, and based on those four factors, was this fair use in the end, in the grand scheme of things?
okay. Hmm. Gosh, I should. Yeah, I'm trying to see if I got a poll here. I should check, see about that. But okay. So does this qualify as fair use? Let's say yes. Okay, we've got one. Ken says it probably is. Lori says it may be questionable because of the effect on the market.
It's interesting that just the fact that two right away have iffy. It may be, and then it may not be. So that's interesting.
And Brian seems to side with Lori's thought that he's leaning to no because of the market. Um, to be honest, this is the first time I've ever heard of this case. Um, I would actually say it may lean to fair use, um, because of the nature perhaps, and who they're giving it to. Like, like they're giving it only to their affiliates. It's not like they're just giving it to anyone, but we'll see.
Yeah,
We'll
I
see.
personally lean towards, even though I think there could be a market effect on the market, but I personally think I would lean towards fair use myself. But again, I'm just the librarian thinking here.
Well, also Brian makes an interesting argument that because health science publications are so specialized, they have such a limited readership and people who would buy and use them, that they have a very limited market. So maybe it would impact their effect on the potential market. So there's an argument for in favor for that.
Okay.
So,
Do you want to move on to number two?
uh, well, what did the
Oh,
court
I'm
give their
sorry. I'm
opinion?
sorry. Yeah,
Sorry.
forgot about the decision.
Okay, sure.
Yeah. So the court held that the defendant's unauthorized photocopying of the plaintiff's articles was fair use because the copies were made for the researcher's own professional use and not for profit or other gain.
Ooh.
The defendants also place strict limitations, and again, this is stuff we don't know because we don't know the ins and outs of this. They had strict limitations on photocopying, which kept the duplication within appropriate confines. And what the heck does appropriate mean here? Because this is where it's all open to interpretation.
Mhm.
The court based its fair use decision on three main determinations. First, that the plaintiff did not prove that it had been or would have harmed substantially by defendant's practices. Um, Second, the court was convinced that the holding the defendant's practices to be copyright infringement would be no doubt harm medicine and medical research.
Mm.
So I guess that's the nature of it right there, right?
Okay.
Um, Third, the court held that balancing the interests of science with those of publishers required a legislative solution. So those of you who said fair use, and again, I already knew that that was coming, but in my mind, I thought it would be fair use.
Mhm. Yeah, but the market really, I think, was the kind of nebulous part of this whole argument. You know, how would it have affected the potential market?
All right, so that was the first case, the early library decision. What's next here?
Okay.
The cat not in the hat.
Ah.
The defendants, Penguin Books and Dove Audio Incorporated, were book publishers who sought to publish and distribute a book titled The Cat Not in the Hat, a parody by Dr. Juice, a rhyming summary of the O.J. Simpson trial.
Oh
Plaint-
wow.
Plaintiff Dr. Seuss Enterprises, LP, owned most of the copyright trademark rights for the children's books written and illustrated by Theodore S. Geisel. Am I wrong on that, Geisel? Under the pseudonym Dr. Seuss, including The Cat in the Hat. Defendants were not authorized to use any element of the plaintiff's original books and did not attempt to obtain permission. Defendant's book had many similarities to the original work, including rhyme scheme, thematic and narrative elements, and certain chief character identifiers, such as the distinctive red and white striped hat. Plaintiff sued in the district, and I can't read the rest of this. It's my screen is
Oh,
full. See if I can do anything about that.
but well, it says plaintiff filed the suit and the district court granted a preliminary injunction. Defendants filed an interloop. I can't pronounce that. I don't know that term. So
Interlocutory.
appeal. Yeah.
Yeah,
So it just
lot to digest there. So, based on what we know about this cat not in the hat, no permission was sought, and they copied a lot of the elements of the cat in the hat. So, based on that, and on the first factor, The purpose and character of the use. Is this fair use?
So no, Leah says no. Okay. Looks like this was for someone's commercial use by Dr. Juice.
Yeah.
Oh. Mhm. However, we can still make a case that even if using a work for profit, I mean, it's not favored, but you still can.
Mhm. Was it transformative? And again, we're not looking at that work, so it's tough for us to look at based on what we just read.
Mhm.
But was it transformative? It was talking about the OJ trial, so
Mhm. Ah, okay. So transformative. So you think Cat in the Hat is that book about a mischievous cat visiting some kids. And now we got this new book that kind of like parodies Cat in the Hat, but it's talking about the O.J. Simpson and Nicole Brown issue. Wow, that's quite a leap. um, so the work either has a new purpose or appears in a new context. Wow. Okay, so
so
Ken
that's my
says,
point. That's my
yeah,
point. Is that transformative?
yeah, Ken says it sounds like it could be. Lori says that the rhyming and other similarities could be considered not fair use, but the O.J. Simpson angle makes it transformative. Okay, so we got those considerations. So
Interesting. The first time I read this, I said this cannot possibly be fair use, and then I thought about transformative, and I'm like, oh, wait a minute.
yeah, and I'm not very familiar with this case either. So thanks, Tom, for stumping me, which is good because I'm on this, I'm on the
No,
same
I think we
page with
should all be
everybody
stumped
else.
on every one of these,
Yeah.
and then find out what the court said and why.
Mhm.
So I guess I'll move on to factor two.
Okay, sure. Thank you.
The Cat in the Hat, fact or fiction. Is this fair use? The nature of the copyrighted work. This
Ooh,
is definitely an art form, writing. I'm saying not fair use.
yeah,
It's creative. It's creative work.
because fair use tends to protect creative works a bit more.
Right. Anybody disagree with that? That would be interesting.
So yeah, I think Kathy says this is a work of fiction. Yeah,
Hmm.
less likely to be deemed. The fiction aspect and the rhyming seem to be highly creative aspects, Lori said. And Ken also says this. Um, and then Leah asks, does it matter that it is based on a factual trial?
Well, that's part of the transformative use, right?
Oh, yeah, yeah, it sure is. Yeah, maybe it's the work. Is it the work itself that's fact or fiction? Maybe based on fact or fiction. Yeah, that kind of changes. It muddies the waters a bit too. And then Brian asks, is it actually a parody? The new work does not parody the Cat in the Hat directly, yet closely resembles many elements of the original work. And that was a pretty big point in the whole Two Live Crew case, is that it's kind of have to have some reference in a parody to make it work.
Right. And there's no given amount that said, you can't say this amount or that amount. So sometimes you do need to have a lot to conjure up the parody.
Yes.
All
And then
right.
Lori asks if they stick to the facts in O.J. Simpson or work or interject tongue-in-cheek humor and speculation. That's that's another interesting consideration. Yeah, I mean, it's really interesting how, the crew here, the galley here is really diving into some of the details and the possibilities. So yes, that's definitely a good approach to take with these fair use scenarios.
All right. I'm going to move to factor three,
Okay.
the amount used. Is this fair use based on factor three?
How much is too much? The less you take, the more likely your copying will deem fair use. There is no specific amount or percentage to determine what's acceptable. It's not really quantifiable. And really, if it's the heart of the work. I think most of us remember heart quite well. Lori says that it sounds like a lot was used. The striped hat is very distinctive and a recognizable symbol of the cat in the hat. Yeah, it should. Yeah, very, very.
But now remember too, in the Two Live Crew case, they they copied the entire baseline, right?
Mhm.
But that was also what conjured up parody.
Yeah.
And again, I guess this gets me back to what was the nature of this, or factor one, even what was this a parody?
Yeah. Well, all right. Well, let's go to the fourth factor and see about
Okay, the effect
it's
on the
involved.
market.
Yeah.
Does it deprive the copyright owner of income? So is this fair use? I'm gonna say it is fair use because it's not depriving the cat in the hat. You're not gonna affect their original market.
Yeah. I mean, it's like a children's story. And I really don't think parents are going to be buying the cat not in the hat for their kids.
Well, some of them may. I may.
Oh my gosh. Yeah, Ken says he hopes not. Yeah, hopes not. Yeah, I don't think this will be read to kindergartners or first graders
No.
or bought in a children's library. So
So
in your,
based on the four, yeah. Are we weighing this fair use or not fair use in the end, in the grand scheme of things?
ooh,
I'm gonna say not fair use.
so, all right, what do you all say to this? Okay, Ken says not fair use. You said not fair use, Tom?
Yes.
Okay. Gabrielle says not fair use. Kathy, Leah, 5, 6. Tiffany says not fair use. Uh, hmm. You know what? I'll be the outlier here, and I'll say it was fair use
All right.
because of the purpose and the effect, and even to a degree the nature, but especially the transformative part of it. But we'll see.
Okay.
Um, Lori says maybe, Deepa says it is. So we've got 3 people who say it could be or lead to fair
All
use.
right. So let's see how those in robes decided this. First, the court found that the use was not transformative. The work was not a parody because it did not hold up Dr. Seuss's style, but merely mimicked it to attract attention or to avoid the difficult work of developing original material. Furthermore, according to the court, there was no effort to create a transformative work with new expression, meaning, or message. Second, the court found that the creative, imaginative, and original nature of plaintiff's work weighed against fair use. Third, the court found that the defendant had copied substantial portions because the character of the cat used in both works was the highly expressive core of plaintiff's work. Other principal thematic and narrative elements were also copied. Finally, because the use was commercial and non-transformative, harm to the market for the original work could be more readily inferred. Further, because fair use is an affirmative defense and defendants failed to submit evidence on the fourth factor, this disentitled defendants from relief from preliminary injunction. So, not fair use.
Wow. So, wow, I didn't expect that. I did not. But so basically the court said that it was not original enough, or it did not really transform the content into something new.
Right,
Wow.
right.
Wow.
Interesting.
Uh-huh.
All right. So we want to move on, or?
And one more thing I wanted to say too is kind of interesting, the last where it said fair use is an affirmative defense, which means that whoever is accused of not following fair use has to submit evidence about the fourth factor, that is the effect on the market. So
Yeah, it's like shifting the burden of proof.
yeah, exactly. Okay. And that's the other reason why I passed along that form to all of you. The URL for the form is, I could redistribute it again, but it's always good to have a record of a fair use determination in the slim likelihood like something like this will happen. So yeah, okay, Tom, we can go
All
on.
right, sure.
Thank you.
I am not even sure what, I forget what's coming up next. The Grateful Dead tickets and posters. All right. So, uh, plaintiff Bill Graham Archives own copyrights in artistic images originally used on concert posters and tickets to promote events for the rock band The Grateful Dead. Defendant Dorling Tindersley Publishing sought permission from plaintiff to reproduce images of 7 such posters and tickets in a 480-page cultural history of the group titled Grateful Dead, The Illustrated Trip. After the parties failed to reach an agreement, DK nevertheless reproduced and displayed the posters and tickets. When DK refused to pay the license fees for use of the posters and tickets after publishing the book, the plaintiff sued for infringement. Plaintiff appealed to the district court's ruling that DK's reproduction of the images in the book was fair use. Should I leave that up for a second if people want to?
Yeah, go ahead. So that we could digest it.
This is a tricky one.
Yeah. So DK, Dorling Kindersley Publishing, reproduced and displayed Grateful Dead posters and tickets, even though they didn't get permission. And then the Bill Graham Archives sued them for that.
Mm-hmm.
And DK, it sounds like they affirmed that, but what they were doing was fair use.
Okay. So let's go to factor 1. That was a good summary, Christy. Factor 1, excuse me, purpose and character of the use. Is this fair use based on factor 1?
Okay, so yeah, Ken says no. Leah says no. DK Publishing intended to sell this book and make a profit. So, okay,
I
so
agree.
it does have a commercial aspect to it, but don't forget, sometimes commercial can be okay when you weigh out the other fair use factors.
C2 Live Crew.
Oh, right. And then, of course, our favorite, the transformative work. So
yeah, I'm not sure how this was transformative, but I'm leaning definitely towards not fair use.
yeah. Lori asked, but did they transform the illustration used? Hold on to that thought. I'm familiar with this case, but yeah, hold on to that little thought. Transformative use. Does it have a new purpose or appear in a new context? And we're talking tickets and posters, which were really quite artful, and involved a lot of
creative works, right?
And they're creative works too. So that's our next factor.
All right. So the nature of the copyrighted work, factor of fiction.
So yeah, so like I said, the Grateful Dead stuff has a lot of artistry, color and imagery and original stuff that, somebody made, dancing bears and skulls and lightning flowers and stuff like that.
Yeah, I'm personally, I'm leaning towards not fair use on this one.
Mm-hmm. Yeah.
Anybody want to lean towards fair use?
Okay, so a couple people had some comments. Lori asked, was the archive holder or the creator of the images? Oh, so did Bill Graham actually have rights over all those images, or was it the archivist who kept the images? So the plaintiff was the archives, I guess, right? They were the ones that were suing.
Right.
Right. Okay. So we can probably assume in this case that the archives held the copyright for those images.
Right. And and we're assuming a lot too, because I mean, these cases, it's not like they went in there one day and decided the case. These things sometimes go for 2 years, 3 years, and back and forth on this stuff. So for us to do this in a 1 hour presentation or so, it's, we're not quite getting everything they got.
Yeah, we're condensing this considerably. And that's really how we're going to be working when we have scenarios like this, whether it's ourselves or our students, we'll have to kind of look into these factors that way and within a short amount of time. um,
Right.
let's see. So Brian made a comment that the artists were hired by Graham to create them, possibly, but he also adds that there were only 7 posters out of a 480-page book. So he talks about the
Factor three.
quantity there.
Factor three. Let's get to that, Brian.
Uh,
The amount used. How much is too much?
yeah, how much
And
is,
is it the heart of it, though? There's that word again.
mhm. I'm familiar with this case, as I mentioned before, and Lori had mentioned something about the images. Um, I was very intrigued about how the court ruled on this in terms of amount used, in terms of images, but we'll talk about that a little more probably when we hear the final judgment. But they made an interesting spin on this amount used.
Okay. Should I move to factor four?
Okay, sure.
Okay.
But it sounds like a lot of people say 3, it's not fair use.
Right.
The third factor.
So the effect on the market based on factor four, is this fair use? Just on factor four alone before we say overall.
So is the fact that DK Publishing printing and selling books about their posters and their tickets, would it deprive the Bill Graham archives of that profit? Or even potential, a potential market?
Potential, right?
Would it lessen the demand for this information? Deepa says, no, this would not be considered fair use. Um, would Bill Graham be losing money on this? Was he actually selling the posters? Kathy says they would not, this factor 4 would not be fair use.
There's a part of me that says, even though I do think they're depriving income based on something somebody else did, but it's almost like in a weird way they're doing them a favor.
Yeah, Tiffany thinks it's not fair use because the archives could have created their own book, and it could be argued that DK Publishing kind of took that from them, maybe. But then Brian says it might actually increase the market by exposing people to the posters, so maybe more people will get interested in the Grateful Dead after seeing the book. So
That was my point too.
All right,
But
drum roll.
the original thing was, is it depriving them of income based on what's out there? And yes, they're not getting income based on that, right? So all right, so let's see how the Supreme Court ruled on this one.
Okay.
The court upheld the district's court ruling that defendants' copying of the images was fair use. It reasoned that defendants' use of the concert posters and tickets as historical artifacts of the Grateful Dead performances is transformatively different from the original expressive purpose of the copyrighted images. The court also reasoned that the fact that the images were copied in their entirety did not weigh against fair use because the reduced size of the images was consistent with the plaintiff's transformative purpose. Interesting. Additionally, the court found that the plaintiff's use did not harm the market for the defendant's sale of the copyrighted work. Again, interesting.
Yeah, I really found the reduced sizes of the images to be an interesting twist on amount used. Yeah, because they were using the full-size poster or the full-size ticket stub that, and instead probably doing thumbnails, if that's how they got away with that. Well, got away with that, or were able to do that. Yeah.
All right. So next case. Not the libraries. Again with the
Again,
libraries. What's up with the libraries?
we're troublemakers. I don't know.
All right. So what's this one about? Defendants included several universities and university officials that collaborated with Google Incorporated on the Google Books project that digitized library collections. In 2008, a group of participating universities created Defendant Hadi Trust to be the administrative entity for the Hadi Trust Digital Library. HDL is a shared digital repository. At the time of the litigation, Hadi Trust membership included approximately 80 colleges, universities, and other nonprofit institutions. HDL contained digital copies of more than 10 million works, published over many centuries, written in a multitude of languages, covering almost every subject imaginable. Hadi Trust used the digital copies to create a database for full text searching by the general public, to permit library patrons with certified print disabilities to have the access to full texts of works, and to allow libraries to replace their original copies that were lost, destroyed, or stolen where a replacement was unattainable at a fair price elsewhere. Plaintiffs, individual authors, and authors associations appealed the district court's finding that the defendants, and again, I can't read my screen because there's something on it.
The defendants were entitled to use the fair use defense. I got you.
Thank you.
Yeah, this is a big one for digitizing books. In this case, we had a lot of major libraries and university libraries digitize the books. And then they were sued. But Hadi Trust used the digital copies for certain, very specific purposes. They wanted to create a database so people could go to a page and search for these books. And another big deal was that it wasn't necessarily just they scanned the books, but they made these books that were available to people with visual disabilities or other sensory disabilities to have access to them because of some changes they made. And also to allow libraries to replace their original copies that were lost, destroyed, or stolen, especially when they couldn't get a replacement so easily. So those are some pretty important factors to consider. This case was a very big deal for libraries.
All right, so let's see, based on factor 1, is this fair use?
Yeah, I'm not sure if I think Hadi Trust might be nonprofit.
Yeah, there's a bunch of nonprofit entities involved in this.
Yeah. And transformative, yeah, keep in mind one of the two of the purposes that Hadi Trust had specified. One, making a database of searchable things. Okay, so, and then also making it accessible to people with visual issues. Lori says that it may be transformative in that Hadi Trust had digital copies from printed books. Okay. Ken said that Ken wondered if the reproduced works were in the public domain. So did they scan books that were in the public domain? And then Lori says, and Kathy say that there is some educational intent and that they were educational entities as the principal organizations involved. And then Kathy states that there was transformative use for those with the disabilities.
Absolutely.
Mm-hmm. Okay, why don't we
All
try
right.
2?
Factor 2, the nature of the copyrighted work. Factor fiction.
Whoa, that probably both. Yeah, that's wow. Talk about a blurry one here. Yeah, Ken and Lori say both. I thought both.
All right. So
Yeah,
is there
Deepa
another?
says both. Mm-hmm.
Yeah. Okay. I don't think there's any way we're going to convince anybody it's not both. So I'm going to move on to factor 3.
Sure.
The amount used. Is this fair use based on factor 3?
Hmm. Well, they scanned whole books. No. Okay, not yet, not so quickly. But true, there is no specific amount or percentage that is acceptable. And then is it the heart of the work? Wow.
Well, if it's all of it, isn't it the heart of
Yeah,
it?
especially for a book. Yeah, and Lori says that the entire amount was used, though some were probably in the public domain,
Mhm.
but assuming that those were not the ones mentioned in the suit. Yeah, it was the Authors Guild that still had copyright protections, right?
Okay.
Mhm.
So I'm gonna go to factor four because that one seemed like a pretty much a no-brainer right there. Factor four, the effect on the market. Does it deprive the copyright owner of income?
Hmm. Has anyone heard the concept? Okay, and Deepa asked if they got permission to scan the books, but I don't think they did.
We
And a
may
lot,
see that. We may see that in the Supreme Court's decision. I honestly don't remember that reading that, but we'll see.
yeah, Ken says they probably had some permissions, but not all. Uh, And then Brian had asked, are the electronic versions available to anyone or only through the libraries? Yeah, that's definitely a point. Who can get access to this information? I know that initially they did make a database where people could, anyone in the public could go to the database and just see like the content, and that the universities would have subscriptions, so to speak, to the full corpus, I guess, of HathiTrust, or like different types of versions of it. Ken also made the point that some publishers that had books in the HathiTrust collection may be defunct. So maybe it's you can't get those books anymore, or they're out of
Mm.
print. So that's another strong consideration too. Mm.
All
And
right.
Lori says that since the full text was not readily available to anyone, it might have little effect on the copyright owner's potential income. So not major, but a little.
Okay. So based on the four factors, was this fair use?
I'm
Yes,
not gonna
yes or no?
I'm not going to say because I know this case, but the rest of you can chip away. Deepa says we are still subscribing, so yes, we didn't shut them down. Good answer. she's
That's
looking to the
awesome.
she's looking to the present. Okay, there's some truth to that. Yeah, Ken says probably. So leaning towards fair use. Hmm. Yeah, Brian. Let's see, Tiffany, Leah, would you like to take a stab or a guess? Yeah. Okay. Leah says fair use. Tiffany's gonna hang with Deepa on this one. Okay. So, and like I said, I withhold my answer because I know how this came out. So, okay, let's.
All right. So I'm yeah,
And
no
then,
oh,
and one more thing. Lori says yes, fair use because they have strict rules for accessing the information. Yes, I believe Lori's used HathiTrust quite a bit, especially with people with disabilities, and also with destroying the copied pages that when they are sent to people with disabilities. So I guess they do have things in place to, once the intended use is over, they destroy the work basically. Okay, so.
all right. So let's see what happened with the Supreme Court. The court held that the HDL's first use, creation of a full text searchable database, was fair. It found that use quintessentially transformative because the result of a word search is different in purpose, character, expression, meaning, and message from the page and the book from which it is drawn. The court further held that the copies were reasonably necessary to facilitate the HDL services to the public and to mitigate the risk of disaster or data loss. In addition, it held that the full text search posed no harm to any existing or potential traditional market for the copyrighted works. The court also held that the second use, access for the print disabled, was fair. It concluded that providing such access was a valid purpose on the first statutory factor, even though it was not transformative. The court held that it was reasonable for the defendants to retain both text and image copies because the text copies were required for text searching and text-to-speech capabilities, and the image copies provide an additional method by which many disabled uh, patrons can access the works. Finally, they held that the fourth factor favored fair use given the insignificance of the present day market for books accessible. I'm moving my
To the
thing to the handicap. Thank you.
handicap.
As to the HDL's use of works for preservation, the court vacated the district court's judgment and remanded for a determination of whether the plaintiffs had standing to bring that claim. That's a grammatical error in my part there. Sorry. So fair use.
Yes, and I think the quintessentially transformative um, because of the database. Fair use makes the search engines that we have possible um, because the courts determined that they're taking all this information and transforming it into a searchable database was different from its initial intended use. So that was one thing that allows Google search and all the others to work.
This to me is just another yet another example of the incredible thought that goes behind all of this with each of these factors and how they interact with each other.
Yeah, and they really held that the full text search really didn't harm the potential market for the copyrighted works. If anything, it probably helped it. You know, more people were able to find these works that were probably buried and buy it or order it or something like that. You know, so
Mm.
and um, maybe even get things printed again that hadn't been in a while, possibly. Yeah.
All right, so I am going to move on to the next case.
Lori asked if
Oh,
data mining was a defense for them in factor one. Um, I believe it was actually. Um, I believe it. I think it might have been.
I would have to look that up. I
Yeah.
don't recall that.
Mhm. I think that was like another transformative use. Mhm.
Okay, the next one, the Rumble in the Jungle, back from way back in the day here. Uh, Monster Communications versus Turner Broadcasting Systems. Plaintiff Monster Communications owned the film rights for the movie When We Were Kings that contained historic footage documenting the 74 title boxing match, often called the Rumble in the Jungle, between Muhammad Ali and George Foreman. Defendant Turner Broadcasting made the documentary Ali, the whole story, which contained a number of film clips aggregating approximately between 41 seconds and 2 minutes that appear in Kings and allegedly are owned by Monster. Plaintiff sued Turner for infringing its copyright in the historic film footage, seeking to enjoin the company from exhibiting the documentary. So that's a mouthful right there. So I'm going to leave that up for a quick second if anybody wants to just.
So Turner Broadcast System had used some clips from someone's documentary, and they got sued.
Between 41 seconds and 2 minutes.
And basically, they really wanted to stop Turner Broadcasting from being able to I guess, release it or to distribute it anymore.
Okay, so based on what we know about factor one, is this fair use?
Mhm. So Turner Broadcast System is a company, mhm, not a educational or cultural institution, nonprofit cultural institution, right? So, transformative use. I'm not really sure what they did with the clips that they used from When We Were Kings.
Mhm.
It could be argued that it's transformative, perhaps, if a new purpose or a new context. Okay, why don't we try factor two?
All right.
Mhm.
Factor fiction. Factor two, is this fair use? This pretty much looks like fair use to me based on this.
Yeah. Deepa and Ken say that it's factual, so it's fair use. Yeah, it was from a documentary, mhm,
Hmm.
and that documentaries are considered factual.
Okay. So I'm going to move to number three,
All right.
the amount used.
So
It,
2 minutes to, no, 40 seconds to 2 minutes. Okay, that's the question.
but is it the heart of it?
Mm. Yeah, what would be considered hearts of the work in the Ali versus Foreman?
How about the decision and what was the final result of the fight?
All right, let's check it out. Ken says it could be the heart of the work. Maybe that's why Monster Communications was not happy about that. Um,
Mhm.
we really don't know if this is the heart or what's the most important part, who knocked out who. All right, number four.
Number four. Okay, so number four, the effect on the market. Does their use deprive the copyright owner of income? Is this fair use or not?
So if people not watch Rumble in the Jungle because they watch the Turner broadcast system, recording or not. Hmm.
And the
Would
thing
it make
here
them?
too is it's
Oh,
potential too. It doesn't mean that it did deprive them, but is there a potential to be deprived?
or would more people be interested in George Foreman and the Foreman and the Ali fight because of that? You never know.
Hmm.
And go rent out and go buy Monster Communications documentary.
All right, so I'm gonna I don't know, Christy, do you want to give her? Do you think this is fair use based on this one or?
Hmm. Well, I know the documentary, and it's really hard to capture the heart of the work. I mean, yeah, I don't know. I really can't say.
I don't know. Based on, I mean, and there's a million places that you can get um, the results from this. And as a boxing fan myself, I know there's a bazillion, and I'll look at any one I can look at. So I think it's fair use because I don't think it's depriving anything. There's plenty of places that you can go to get this factual information.
Okay, all right. Let's go with that. Ken asked if Monster did the original filming in the 70s. I think they did. Yeah, because it was based on footage like going to Africa and there and everything. So they
Hmm.
followed it as it happened. So,
Okay, so in the end, though, is it fair use based on all of those factors?
well, okay, I'll make okay, Deepa says fair use. I'll go with Deepa.
I'm gonna agree, Deepa.
Okay, Ken says yes. Mhm.
Okay,
All
as the
right.
results come in, I'm just going to go right to the Supreme Court here. And they denied the plaintiff's motions for injunctive relief because it concluded that the defendant was likely to prevail on its argument that the use of historic footage in its documentary was a fair use. In reaching that conclusion, the court found that the defendant's work, while commercial in nature, undeniably constituted a combination of comment, criticism, scholarship, and research. The court also determined that the amount used weighed in favor of finding fair use because it was not the focus of the defendant's documentary. Additionally, the court found that the defendant's use of the footage was unlikely to harm the market because the use was too few, too short, and too small in relation to the whole. If the broadcast of story impacts King's reception, it almost surely will be the result of their common subject, not the minute or so of common footage, not the minute, excuse me.
Mhm.
Finally, the historic nature of the,
Alleged
help me out.
infringed film clips also supported a finding of fair use.
All right, so that was a pretty interesting one.
So a
Uh,
lot of you had said that because it was factual, that would help in a fair use argument. Some people talked about the amount, but the court, I liked how the court said it constituted, their use constituted a combination of comment, criticism, scholarship, and research. And that's really a big part of the purpose of fair use that allows you to do all those things with copyrighted works.
all right,
Oh,
Seinfeld.
all right.
Seinfeld
Oh
trivia.
boy.
Let's see what this is about here.
A publisher called Carroll Publishing Group Incorporated had created a Seinfeld trivia game. I believe they did that without the permission of Castle Rock Entertainment Incorporated. So Castle Rock Entertainment Incorporated, who had the rights to the Seinfeld, to make derivatives of based on the Seinfeld show. They'd be the ones that would legally be able to do this, but Carroll Publications did it. So would this be a fair use that they had done? So when you think about the factor one, the purpose and the character, was the publisher doing this for nonprofit or educational purposes? And was it a transformative use? Seinfeld was a very popular TV series, but yet this was a game. So we got the factor one, fair use to consider. Okay, Ken says that it sounds like it's transformative, so does Brian. And a couple of people also said that it was commercial use too. Let's see, I'll go to the next one. All right. So for factor two, we've got the, was it a factual work or a fictitious work? Oh man, Tom said that his entire building lost power. So if we could just go through this next case as another application of fair use and a legal case, we'll just wrap it up after this. It's different without him. So whether this is fact or fiction, this is a creative work in a way, not a documentary, not something that actually happened. Yeah, a lot of people are saying fiction here. And now we go to the third, the amount used. How much is too much? The less you take, the more likely your copying will be deemed fair use. So that's going to be kind of a tough one to discern, how much is too much? What do we got in terms of content? That's a bit more vague.
Christy and everyone, can you hear? If you can hear me, I apologize. My entire building,
Thank you. I'm so glad you're back.
my entire building just lost all power, and I'm like, you're kidding me.
Okay, all right. Well, oh gosh, well, I'm glad you're back. Basically, I just went to the third factor of the Seinfeld and the Carroll Publishing that made like that game, for Seinfeld trivia. So. And Ken says that, okay, I'll stop my screen share.
One sec.
The wonderful world of Zoom and working remotely. But thank you so much for bearing with us.
Okay, so let's see. You were on how much is too much?
Yeah, how much is too much? And then Ken says that all the content would be taken from the show. Deepa feels that it would not be considered fair use for factor number 3. Ooh, in the heart of it. Oh boy. I mean, Seinfeld's known to have lots of quotable moments that everybody remembers and quotes when they drink or in a Seinfeld mood. So maybe they capture the heart of these works quite a bit. But let's go to factor 4.
Can I just ask, because I missed it, what did people mostly say about factor 1?
Factor 1, commercial.
Okay.
Yeah, because Carroll Publishers were doing it as a for profit to sell it.
Okay, factor 4, the effect on the market. Thoughts on this? Is this fair use?
Let's see. Ken said that it would all be taken from the show. That is that it would deprive the Castle Rock Entertainment of it. Kathy agrees. I think about the basic rights creators have with the copyright, and that is to create derivatives and to profit off the work.
Yeah, I'm totally leaning towards. In fact, even with the 4 factors, I'm leaning towards not fair use.
So, yeah, I'm leaning to not fair use too.
All right,
I'm looking. Combine everything.
I'm looking at the time too, and I think there's also one more case, but I think. How did the Supreme Court rule this? It wasn't the Supreme Court, it was the Second Circuit that held that the defendant's unauthorized use of the copyright protected aspects of the television series was not fair use. The court determined that the defendant's use was commercial and, more importantly, non-transformative because the SAT did not provide commentary or analysis about Seinfeld or act as a research tool, but instead repackaged Seinfeld to entertain Seinfeld viewers. The court then noted that the defendant's creation of 643 questions based on the TV series was more than necessary to advance defendant's purported commentary of the show, further suggesting that the book's purpose was entertainment. Turning to the effect on the potential market, the court found that although Castle Rock had shown little interest in exploiting the market, the defendant's work substituted for the derivative market for such books as, and the court noted, help me out here, that copyright law must respect the creative and economic choice of plaintiffs not to exploit a particular market. Any thoughts on that?
Let's see. Well, Lori said this before you read the outcome, but she said that she thought that there would be little negative effect on the income and that maybe people would be inclined to watch Seinfeld episodes from playing the game. Yeah, and Deepa feels the same way too. They would have to watch the show, but then they would have to watch the show to be able to play the game. So you can kind of say that as a counter argument potentially.
All right. So,
but it sounds like the court said this would not constitute fair use because of what it's depriving the copyright holders.
right. On a whole, right? Not necessarily, they might have agreed with certain things that some of us have said, but on a whole, it's not fair use.
Yeah, okay. Well, we have the work cited here, so you can go back and take a look at these cases. It looks like you got a lot of these summaries from the US Copyright Office's Fair Use Index, which is a great source of current and past cases about fair use. Also, I wanted to add that on March 26, I believe, Kenny Cruz is going to be providing a fair use webinar that talks about the current fair use or very, very recent fair use cases that are out. It's going to be Friday, March 26, 2021 at 2:00 p.m. our time for 1 hour. And Kenneth Cruz, who does a lot of work with copyright and libraries, is going to talk about the current cases and how the interpretation of fair use has changed radically because of COVID. There's a lot of special uses and issues taking place now because of that. And Kenny Cruz is going to help us explore some of those cases and talk about new possibilities and their implications for what we do. So March 26, I sent an email about it this morning, so you all can get a sign up to register for it and join us for that particular free webinar. And also, if you can't appear at that time, they're really good about giving the recording and making that available to you afterward. So we strongly would recommend that as a follow-up to this little fair use series. So, Tom, was there anything else you wanted to add?
No, I apologize for creeping out there for a little bit, but thank you for attending, and I hope it was at least interesting.
Well, thank you all so much for attending today and deliberating these finer factors of fair use. And all the attorneys assure us that the more you go over it, the more you feel comfortable about applying and using fair use, because fair use is a right. We do have the right to use it despite all the limitations that our publishers may have and digital environments may put on us. It is still there. We still do have some rights. And we would just love to have everybody more comfortable and familiar with all of these possibilities. All right, was there anything else anybody in the audience wanted to say? Thanks again for being with us today, but any final parting words? All right, well, on behalf of the Copyright Working Group, thanks for coming in today, and see you next month with more masterclass workshops. So thank you.